Welcome back to the program. Well, despite a slow start to the Fair Work Commission's Stop Bullying jurisdiction in 2014, just prior to Christmas, full bench of the Commission handed down a decision to clarify the meaning of at work in the context of the phrase bullied at work. The full bench found that a worker will be at work if they are performing work or undertaking an activity authorised by their employer, but also indicated that this definition could lead to ambiguous or arbitrary results going forward. Here to discuss the decision in detail and what it means in our regular workplace law commentator, Joydeep Hor, Managing Principal of Specialist Employment Law Firm People and Culture Strategies. Joydeep, always good to have you on the program. Can you just put it in perspective? Why is this an issue, and in particular in regarding what work means and the relevancy of it?
Sure, James, good afternoon. It's important to appreciate that the anti-bullying laws that were introduced at the beginning of 2014 were very much a proactive step by the government, the former government in fact, to try to ensure that any employees or others who were in workplaces who felt that they were bullied could do something about it. They could make an application to the Fair Work Commission, seek the intervention of the Fair Work Commission by way of orders that the particular conduct, if it was considered to be bullying, stop. Now, essentially, part of that framework required there to be some limitations and indeed prescription around where that conduct occurred, and unsurprisingly for a workplace jurisdiction, it was limited to circumstances where the bullying occurred at work. Now, the reality is the modern workplace is very different to the workplace of 50, 60 years ago or even 20 years ago. The workplace is not just limited to the physical boundaries of a primary place of work, and indeed is not limited to the core working hours of 9 to 5. It's a lot more fluid than that. And indeed, this particular case saw a number of maritime workers essentially claim that they'd been bullied on social media, well outside the boundaries of the physical workplace, but that because that conduct had been meted out to them by co-workers and indeed others, and there was an alleged failure on the part of management to deal with that particular conduct when escalated to them, they wanted to argue that a far broader definition of at work should be considered by the Fair Work Commission. So it was a very important case in that particular context.
We made reference to it just in the introduction, but what are some of these ambiguous or arbitrary results that could result?
Well, the Fair Work Commission said that there's got to be a sufficiently strong connection with the workplace, and in fact, for the purposes of the bullying laws at least, it's only going to be at work if you are performing duties or engaging in activities that are authorised by the employer. Now, that doesn't mean that it has to physically be at the workplace or between core working hours, but if it's not conduct that has been authorised by the employer or required to be done by the employer, it's not going to be at work. When the full bench talks about these so-called arbitrary and ambiguous results, I think it's having regard to the reality that what happens when someone, for example, is at a conference that is paid for by the employer. Sure, that is, the attendance at that conference might be authorised by the employer, but what happens when a group of people might hypothetically go out for a drink after the dinner or after the day's events at a particular conference? The person has no choice but to be at that location, which is the conference venue, which has been authorised by the employer. So where is that magic line going to be drawn? I think that's what the Commission's referring to in talking about these potentially arbitrary outcomes.
Well, I suspect importantly then, Joydeep, for employers, look, what should they be doing, what should they be thinking as a result of this case?
I don't think employers should be too joyous, if I could put it that way, that there's been a limitation on what workplace boundaries are. We've seen plenty of sexual harassment cases and other cases over the last few years which really confirm that the actual boundaries of the modern workplace are a lot more blurred. Sure, in a bullying context there's been some limited clarity, but in that acknowledgement that it is always going to be case by case, the employers need to be very clear that when employees are interacting with each other, my advice would be, regardless of where that conduct occurs and when that conduct occurs, it's very important that there is some cognizance that there could be a touch point back in the workplace. The mere fact it might not result in a lawsuit is one thing. The fact that it could impact on employee relations and the corporate brand are far more important considerations.
Absolutely. Joydeep, thank you.
Pleasure.